Welcome to Looking at Legal Stuff. Today we have 10 hearings in a case with a couple where dad has been ordered to make monthly spousal support payments, but he's been blowing them off for the past year. Mom has been bringing him to court for contempt after contempt, but despite her getting judgments from the court for the arrears, he's still not paying her. She says dad is additionally supposed to pay for half of the children's school clothes and their extracurriculars, but he's failed to reimburse her for any of the receipts she sent him. Mom also claims that the children have been telling her that dad is drinking when they are with him, despite a court order that prohibits him from drinking during his custody time. She says the children are scared and worried about him drinking and driving, and she's afraid for their safety. The commissioner has told dad that he'll be sent to jail for not paying, but will he actually follow through with that threat? Or will the commissioner continue to let him get away with thumbing his nose at everyone? Let's find out.
I'm here. Sorry, I could not find the mute button.
Is Bryce Chapman with us?
Nope, he won't be.
I'm going to mute one of these people here. It's not letting me mute it. Just a minute here. I'm just going to remove that person. Okay. All right, Ms. Chapman, let me get my notes. Mr. Chapman was here last time, and even though it wasn't the full amount of child support, I required that he pay you at least $500 and provide me a current wage statement. Nothing was filed, and did you receive the $500?
I have received nothing. And actually, so I asked for half of my daughter's basketball, or at least get her basketball shoes or a basketball, or even $10 shorts. Nothing. And actually, come to find out, his license gets suspended on the 18th because he did not pay a ticket, and he didn't show up to court, believe it or not, for that either. And so, and he's been paid, I believe, twice in the month, and nothing. And I'm struggling over here. I'm going to school, and still, I mean, it's hard to make it with the car payment, the rent, the kids, and everything else, and no child support since September. These payments not being made for the whole year that they've been ordered. And he barely shows up for visits. He still smells like alcohol when I do see him. I mean, it's a lot. And he's just not taking things seriously because I think he just thinks that nothing's going to happen. And I'm at the point of just being completely fed up of the no help and toying with his kids' emotions and them not getting the support that they need financially. So I'm over here with nothing and still making sure that they can do the sports and do the things that they've always done, even if that means it leaves me with $1. And it's rough.
Okay, thank you.
He did inform me he was not going to be at court today and wanted me to let you know his excuses of no payments. And I don't feel that's my job to do so.
All right, I'm looking at your proposed order.
think this might be the fourth contempt or fifth. I don't know. I mean, there's more that I just didn't file because I don't know.
I'm making some modifications to it. I'll go over with you in a moment.
Oh, one more thing. He did actually lie to you about the place of employment. It's actually New Legacy, not Win-Win, like he said.
All right, the last contempt order I signed covered the period from August to October. I think that was the beginning of October. This
I don't.
contempt order, well, you've written September 1, so that was covered in the other one. So we need to go October 1st.
Who knows? Like, who knows? It's been the entire year. I think in February of last year it was ordered, and there's been no payment since, I mean, ever. It was ordered. So I don't know how much that is at this point.
So I'm going to ask you some numbers here in a minute. I'm going to have it go from October 1, 2022 to January 31, 2023. And what is the child support amount per month?
This one is for the spousal support and car payment, and so that's $250 plus $250 a month, so $500 a month. Child support is supposed to be, I think, $1,600 a month or $1,100 a month. I'm not sure because they lowered it for some reason.
Well, October, November, December, that'd be 4 months. So I'm going to put that at 4,400. Again,
Last time we mentioned jail, and I don't want him to go to jail, but at this point, nothing is going, he does not think that there is any repercussions for anything at all.
Spousal support is
Well,
$250 a month. Is that right?
yeah, yes.
Okay, so that's going to be a total for 4 months is going to be $1,000. And the car payment is $250 a month.
Yes.
So that's another $1,000. Okay. All right. You might want to write this down. This contempt order is going to cover the period of October 1, 2022 to January 31, 2023. So that's a 4-month period. And I've taken all those monthly amounts and multiplied them by 4. If you file a subsequent contempt order, then you'll want to start with February 1st, 2023. Okay. I have indicated he can purge the amount he owes by paying $3,000 by February 15th, 2023. I am setting a review hearing for February 15th, 2023. And I understand you don't want to send him to jail, but that's the next step. So if the $3,000 is
At
not
this
paid,
point,
if it's not paid by February 15th, then I am going to order jail time at that point. I believe this is the 4th contempt order I've signed this year. And last time, as I indicated, Mr. Chapman indicated he would make a $500 payment, and he had just started a job, and he was going to give me information about how much he was earning, and he's done none of that. So at this point, he gets one last chance. Otherwise, I will order jail time.
Okay, and I have one quick question regarding his suspended license, um, which has nothing to do with this, so I'm not sure if you can go on to that, but what do I do about that? Do I allow the children to go to visits until that's resolved? Like, I don't know. Do I need to file something?
It's typical that if a parent drives a child, they have to have a valid driver's license and insurance. So if he doesn't have a valid driver's license, he can't drive the children. I don't know that it changes visitation if he can arrange some other way to have them transported. But if he can't, then that probably does affect it. Okay.
That's what I was thinking. Okay. Okay.
And if you believe the court should make a change in the current visitation plan, then you can make a motion to that effect.
Okay. I feel like it's necessary, but I just don't want to go down all that again.
Okay. All right, I've signed that contempt order and we'll see you back here in 2 weeks, okay?
Okay, thank you very much.
Thank you. Brittany Chapman, do you want to unmute yourself?
Sorry, I'm here.
There you go. Thank you. Just letting somebody in. Did you receive any money in the last few weeks?
No. He got actually super upset with me about all of this, and it's turned out to be my fault somehow.
That's what he's saying.
Oh yeah.
Okay.
And I've let him know, which is not my job again, multiple times, that courts today, that I reminded him, like, courts in a couple days, courts tomorrow. Is there, I mean, even if you make an effort, like if you can do anything, I'm sure that you'll, get a little longer, and nothing.
All right, let me just make sure. Is Bryce Chapman with us? All right.
So, I mean.
So let me just, by way of beginning here, we were here on February 1st. At that time, I granted a motion for contempt. I indicated that it could be purged by a payment to you of $3,000 by today. And then I said, if not paid, the court will order jail time. And I set a review hearing for this morning. So before I make that ruling, I want to go through some of the history. On September 28th, 2022, I entered an order of contempt, and the payments owing at that time were $900, $3,700, and $500. That's a total of $5,100. On October 26th, I entered another order of contempt. The payments owing were $900, $250, and $1,000. On December 22nd, I indicated that he had to pay you at least $500 and file a wage statement. Neither of those occurred. On February 1st, I entered another order of contempt in the amounts of $4,400, $1,000, and $1,000. All of those contempt amounts add up to $13,650. The court wants to make clear that it's provided multiple opportunities for Mr. Chapman to pay something.
And he is making a truck payment of over $700, and he is buying cocaine. I found out actually just this last weekend. So he does have money. He just
Okay.
refuses to help with his children or anything in any sort of way. He doesn't think that he'll ever have consequences, or needs to be held responsible for anything, unfortunately. I think this
All
is the
right.
issue.
So let me say two things. First of all, each of these contempt orders are judgments, and they can be collected like a judgment, which means wages could be garnished and so forth. I can't do that as the court, but that's something you could look into.
I have no clue how to do that. I have tried. I tried to, and I have to.
I
more
understand you may have to talk to an attorney about doing that.
Yes.
That's the best I can say. What I can do is with the multiple contempts, including contempt today, I'm going to order that he spend 5 days in jail. I'm not sure when I'm going to order that begin. It'll be sometime between now and 2 weeks from now. And 2 weeks from now is March 1st. So I'm going to set a review on March 1st to see if he's served the jail time. If not, I will issue a bench warrant for his arrest on March 1st. Okay. And we'll see if that changes some attitudes and tries to get some payments made. Okay.
Okay. So between now and March 1st, he can either go, he needs to go serve those 5 days.
Yeah, I'm going to do another contempt order. I'm probably going to say he has to report by this Friday and serve the 5 days. If he doesn't, he can serve after that anytime before March 1st. But if he doesn't serve 5 days by March 1st, then I'll issue a bench warrant.
Okay.
Okay. So why don't you come back here on March 1st and we'll see what has happened by that time. Okay.
Okay. And should I go grab the, sorry for so many questions. When he doesn't show up, it makes me have more questions because I have to also be his parent. So should I go grab these papers, the orders, and send a photo of those to him like I did with the last court date? Or is this not my duty? Otherwise, he's not going to know. But also, it's not my job. I'm overwhelmed with all this stuff that I do as parenting them on my own, anyways.
Right.
And then to tackle his stuff on top of it is.
Well, you're not obligated to do that. If you want to, you can, but I don't think that's your obligation.
I agree. You're right. I'm too nice. Okay.
Okay.
Okay. Oh my goodness. All right.
All right. We will see you back here then on March 1st. Okay.
Okay. Thank you.
Yeah. Thank you. Brittany Chapman and Bryce Chapman.
I'm here.
Is Bryce Chapman here? All right.
Honor.
Oh, Bryce Chapman?
Yep, I'm here.
Okay, good. I'm glad you're here. So there have been some promises that you were going to make some payments, and I've signed several contempt orders because the spousal support payments have not been made, along with other payments. I know you and I were here around December, and you had promised you would pay $500. All of that resulted in a couple of weeks ago, I ordered that you spend 5 days in jail. And I'm glad you're here today. I need to hear what your plan is to make these payments?
Your Honor, I'm sorry I neglected the court and the orders. I'm asking if I can have more time to review with my lawyer, so I can put in with my response. I plan on making payments and doing stuff. Half my checks are getting garnished with child support, so my wages are cut in half from my old job to what they are, now is half of what I used to make. That was sent through with child support services. They are aware, and they're taking out of my company I'm working for now. So I'm trying the best I can, but there's no other, good reason. That's how it is right now. I will plan on trying to come up with some kind of payment plan that I can do, but as of right now, I'm sorry that I neglected the orders and did all that.
Do you have an appointment with an attorney that's scheduled?
I talked to her last night, and I'm going to talk to her again after I get done here, and we are going to sit down and meet and then have write up a response.
All right. Thank you. Ms. Chapman?
The way that I see it is these orders were made February of last year, when he was making very good money, and he still was not making any of those payments the entire time. So I don't see any of those things as valid excuses or reasons. And as far as a lawyer goes, I do not believe that at all. And if you have money for a lawyer, how come you don't have money for even paying for a sport for your kid, or money to make these payments at that? And also the 5 days were not spent in jail. He didn't even do that. And again, the lawyer thing, I just don't believe it. And during all the child custody battles that we just went through with you already, no lawyer was done then, but now it can be. And you're going to wait till the night before court to do so. I just don't find it believable. And the threats that were made when he found out about the jail time were pretty gross. And I just don't believe it. And the 5 days needs to be spent still. He is very good at trying to get out of consequences by making whatever story that he can make up and missing all of the court dates that he has missed. But now that it's down to he has to go to court, he wants to show up. And I'm fed up with all of it at this point. And there is a lot of sports to be paid, but you can pay for a lawyer, which is, again, I don't believe. And I think that's it.
All right. Thank you. We have been here quite a few times without any effort really to make the required payments. And that's certainly frustrating to Ms. Chapman and noted by the court. When somebody comes in and says they want to meet with an attorney, there's really no way to assess whether that's valid or not. But I very typically will give somebody time to do that. And sometimes the attorney can be helpful in getting these issues resolved. So I'm going to put this over 2 weeks, Mr. Chapman, to allow you to meet with your attorney. So that's to March 15th at 9:00. I'm not removing the requirement to spend 5 days in jail at this time. That may come up later. But I am interested, if you meet with your attorney and if you put together a payment plan, I'd like to see that on the 15th. In fact, if you don't have a payment plan on the 15th, I'm going to be a bit concerned. Okay. So let's take a look at that. My interest here is not to put you in jail, is not to do anything other than get Ms. Chapman paid.
Okay.
And I will use whatever tools I need to get that done. But at this point, I'll give you 2 weeks in order to meet with your lawyer. Okay.
Thank you, Your Honor.
All right. So we'll be back here on March 15th. Ms. Chapman, yes.
Haven't we had a whole year of chances? I don't want him to go to jail either, but it seems every time he does show up to court, which is few and far between, he just gets another slap on the wrist. And he was ordered 5 days in jail before the first, or there would be a bench warrant, and he did not do so. And then he shows up today magically. And then now it's just another slap on the wrist, and he's not getting it. And I'm just frustrated with the mental and emotional abuse that goes on regarding this. And I don't know. It's never gonna end, ever. And I just spent $250 to put them in sports, and I don't work. And he made $37.50 for the entire year that this has been ordered. And now the excuse of, well, my job doesn't pay as much, the job that he just started working. So I don't, is there a bench warrant as of today, like there was supposed to be, or no?
We were going to consider a bench warrant today. I'm not going to issue that. And let me just say, I understand your frustration. But again, my usual practice, and I'm not going to deviate from it now, is when somebody comes to court and says, I need more time to see a lawyer, I typically give them that time. I know there's been a lot of non-compliance in this case. Ultimately, we'll address that. But I'm going to give Mr. Chapman time to meet with his lawyer. Okay.
I just hope that the money he should be paying me isn't what's going towards this lawyer from the money he claims to not have. So that would be unfortunate.
And that will be a factor I'll consider.
Okay.
All right. Thank you. We'll see you both back here on March 15th.
Okay. Thank you.
All right. Thank you, Your Honor.
Brittany Chapman and Bryce Chapman.
I'm here.
I'm here, Your Honor.
All right, Mr. Chapman, you filed a declaration saying that the most you can pay would be $250 a month. Have you made any payment at this point?
I have not.
And why not?
Since our last court date, is that what you're talking about?
Well, you haven't made a payment in a long time.
Ever.
You indicated you could pay $250 a month, and it would seem to me you would show good faith by making some payment by today, but it sounds like you haven't.
I can make a payment by the end of the month. That's for sure. A $250 payment.
All right. I'm not sure that's going to be enough, but Ms. Chapman, any response?
Yes, since I did not have time to respond to the declaration, I did actually prepare something to say. So today Bryce was supposed to submit a proposed payment plan written by him and his lawyer regarding the total amount owed. He has not submitted the payment plan. He has submitted a declaration. He's been found in contempt 6 times, does not show up to court, nor even attempt to follow an order. Nor did he submit his income to the court for our prior hearing. And at this point, I think the punishment needs to be served. He's delayed the proceedings due to making a claim he was going to be retaining a lawyer, when he in fact was not, and also agreed to the court to be submitting that lawyer written payment plan to the court before today, and did not do either of those things. As far as the improper declaration, it does not state facts. It is not a viable payment plan. Instead, it was a way to buy time, badmouth me, and manipulate the system to avoid further punishments. Stating child support garnishes 50% of his paychecks is not accurate because it is also not legal for child support to do so. He also owes the IRS money, so they are taking for that too, as far as I understand. Referring to the clerk's notes, he was supposed to serve jail time, also was supposed to come today with the lawyer presented payment plan. His behavior time and time again shows he believes the rules don't apply to him. I'm ready for this to be done, being dragged out, and the amount he says he owes of $6,500 changes many times throughout the declaration, but the total amount owed is $13,650 from my understanding. I would also like to request to see the receipts from the spousal support payments of $1,000 he claims to have paid to me, because I have never received $1. So maybe those were paid to Brittany Chapman, not Brittany Hancock, which is now my name.
All right, thank you. Mr. Chapman, any response?
Yes, Your Honor. I do have receipts, and I have receipts that she has signed. And yes, it was with Brittany Chapman on it because that was her name.
Those were maybe child support from 2 years ago.
Mr. Chapman, let's let Mr. Chapman respond.
And I have receipts from money orders that I've paid, that totals in that amount. So I would like to show, and I can show pay stubs of garnishment from child support of 50% of my wages since I started my new job. And I can present those and print those off and turn those in to show. And as far as a lawyer, I had legal aid advice. It was not a lawyer. And this is what we brought up and came to present.
Can I speak, Your Honor?
Go ahead, Ms. Chapman.
I believe that the receipts he is speaking about are right after he moved out of our house, because I totaled up the receipts that I had because I believed that's what he was talking about. And that was when we were just going to be doing child support on our own without the court system. That was child support payments. And that was long before spousal support was even ordered. So I do have those receipts as well. But that is not towards this at all. And as far as child support, they literally can't garnish 50%. But if he says he can submit those, he should have submitted all the other things he was supposed to do.
Mr. Chapman, we've been here several times. Sometimes you were not here, although you were served. We've been here several times on contempt orders for spousal support, and I think a payment for the car. And each time I entered an order to make those payments, nothing happened. I finally indicated that I was going to order 5 days in jail. And then the hearing after that, you did show up, which was the last time we were here. And I just want to check the date on that. That was on March 1. You were to come up with a payment plan. By that time, you wanted more time to meet with an attorney. No attorney has appeared in this case. You've indicated that 50% of your wages are being garnished for child support. I don't believe that's true because wage garnishments are not that much of your wages, but we'll see. You've indicated you made some support payments. I don't have evidence of that. And honestly, I don't believe it's credible that you can't make a payment more than $250 a month. So I'm going to put this over, and if you've got something to write with, you need to write this down. I need to see wage stubs showing the garnished amount for at least the last 3 months. If you've made spousal support payments at any time, I want to see those receipts. And you need to pay Miss Chapman $1,000 by the next time we get together, which will be a week from now. So that's going to be the 22nd of March. If I don't have your wage stub showing the garnishment, if I don't have the spousal support receipts, and if you haven't paid the $1,000, I'm going to order that you report to jail by the next Friday. If you don't report to jail, then I'm going to issue a bench warrant. So those are the things that are going to go on. This has been bounced along over and over without any meaningful response from you, Mr. Chapman, and it's time to have a meaningful response. So that's what I require. We're going to be back here on March 22nd. File all of those documents with the court so I have a chance to review them before the hearing. All right.
Okay.
All right. Thank you.
Thank you.
Next will be Chapman and Chapman.
I'm here, Your Honor.
And I'm here, Your Honor.
All right, Mr. Chapman. So, Ms. Chapman, did you get the $1,000 check?
I did, and I actually again prepared something to respond to the papers that I was served yesterday because I did not have time to properly respond.
Do you want more time to respond to the papers he sent?
That's okay as long as I can have it just a chance to read what I typed out. It's not too long, I think.
Okay, I will hear from you then if you want to read what you typed out.
Due to the untimely service and
Can I ask you to speak up a little bit? You're coming through a little light in the courtroom here.
Due to the untimely service and filing on Bryce's behalf, I did not have time to properly respond. I was stalked and intimidated all day. I agreed to meet Bryce's girlfriend, Maggie. When I arrived to meet her, Bryce's mother was there, which scared me because she has filed false police reports on me, among numerous other things. So I chose to leave as she poses a threat to me, and I also was supposed to be meeting Maggie. They proceeded to stalk me to the dealership where my car was when my friend gave me a ride there to see if my car was done. They oddly enough showed up at the exact same moment, to which she later admits to a police officer after calling them to clear her name in fear that I would be calling on her for her continuous stalking of me and using the children as a pawn and following them home from school that day, causing them even more emotional turmoil than they already are suffering. She admitted all these things to the officer who advised me to file an anti-harassment order. As far as the things Bryce submitted to the court and the money owed, he did in fact pay the $1,000. Why and how he could come up with the money suddenly when being faced with jail time, I don't know. The receipts submitted for spousal support really got me because 9 of those receipts were deposits from when Bryce and I were still married and still lived together in the same home. If you look at the date, it says May of 2021. Bryce and I separated July 3rd of 2021. He had to deposit his paychecks into my account because he could not have a bank account of his own at the time. As far as the actual money order receipts he submitted from between the dates of July 2021 and November 2022 are inadmissible to this case because those receipts were in fact for child support, as I stated last week when we were here. As the spousal support order was never brought to the court or signed by you until February of 2022. So therefore, none of the receipts are admissible. So the spousal support he claims he paid me was also a lie. If you add up the total of all the money order receipts, it also adds up to $2,200, not $1,000 that Bryce stated he paid me. So many of the things said do not add up or make any sense. Bryce submitted his budget/bills, which the court never asked for that. He only shows here the amount of responsibility that he does not have. No rent, no house bills, none of those things. I have all of those. Fully support our 3 kids and all of the above. And again, nobody asked for his budget to be brought forth today. If you got a chance to look at the child support income withholding notice submitted, the reasoning for them garnishing such a high amount is due to him being so behind in child support. In total, between this amount owed and child support, he owes a total of $24,000. So them garnishing 50% makes sense now, seeing the paper. The $732 truck payment seems to be his primary responsibility, which is disturbing. And his girlfriend is also the primary on his truck. So if he can't afford his true responsibilities, maybe he needs to give that up. Your Honor asked for pay stubs for the last 3 months to be submitted, which he did do that, but here he also submitted an entire year of 2022's pay stubs, proving yet again what Bryce can and is capable of. And the living the kids and I were used to before I had to leave the marriage because of the addiction issues, mental and emotional abuse, and manipulation that was taking place for years. With all of this being said, and including the fact Bryce is not the one who filed these papers, but his mother and Maggie, in an untimely fashion, nor is it what the court asked for. It was even more lies in the simple fact he could clearly have paid me the entire year I've been dealing with this. I asked that the court order the previous punishment. I also asked that a strict payment plan be put in place. I've wasted enough time, energy, money, and stress with this just for him to sort of do what he has asked the second jail is brought up and then cause the things that were caused yesterday for me and the kids.
All right, thank you. Mr. Chapman, any response?
Yeah, Your Honor, I wrote up a statement to present. The number 744 or $744.54 is the amount that I have left for the month to pay for food and gas to get to my alternating job sites. I was unemployed for 4 months, September 2022 to January 2023. I struggled dealing with unemployment and was receiving no income those months. To pay the $1,000 to Miss Hancock/Chapman, I had to borrow from my dad, and I will have to pay this back. I handed that check to her on 3/19/23, and I have provided a copy of the money order. The payment of $250 the amount I thought was appropriate based off what I can afford. Not to mention $744.54 is the amount I have left when I have my children with me and for me to live off of. I try to provide for them what they need when I have them. I have provided a copy of most of my pay stubs for 2021 and 2022 when I worked at J.H. Kelly to show my pay and garnishment including child support. I have also provided copies of my pay stubs from Legacy 6 that show that 50% is being taken from my check, with other money orders that I have paid her on top of garnishment. I am trying to get my life on track. I apologize for all this wasted time with these motions. As I mentioned before, I was properly served to understand that I was causing more problems for myself. I am trying to provide for myself and my kids when I have them. I seem to get roadblocks with Miss Hancock/Chapman, and the rejection of my taxes is an example. I did my taxes this weekend, and my returns, any returns I receive will automatically be garnished to my back child support. However, I received an email stating that they were rejected due to Brody being claimed by someone else. In our final divorce paperwork, it is written that I am to claim only Brody. That is $2,000 taken away from my tax refund towards my garnished amount, not counting the effort it takes to refile and explain to the IRS, explaining my rejection and reasoning the rejection happened. On 3/21/22, my mom handed Brittany the copies of my paperwork you're reviewing at her home after several attempts of meeting up with her. She was supposed to meet at 12:30 at Target. No show. My mom went to the house and rang the doorbell while the car was there. No answer. My mom walked the kids from the school 2 blocks from the house. Brittany opened the door screaming and threatening to physically harm my mom in front of the kids. I have the police report from my mom as she reported to the sheriff's department. This is the second time that she has threatened my mom, and previous time it was physical. I ask that this is reviewed today as well. I have the statement from my mom that she filed. The officer's name is Officer Mosley, and his phone number is 360-998-0991. If you allow me to, I would like to use the exact words she used towards my mom if you'd like to hear it today.
So that may be relevant in another setting. I'm not going to make a decision based on that interaction because we're not here for a restraining order or a protection order. We're here about the financial issues relating to spousal support and the payment for the vehicle.
Okay. So I paid, Your Honor, I paid the $1,000 and I provided you my pay stubs that show that I'm garnished 50% of my wage, and it shows my February paychecks and my March paychecks of when I started with Legacy 6 and how they are deducted with the child support, and it says that on the pay stub. And it leaves me with, I mean, March paychecks, I have $744, and that's not counting my fuel, my food, my anything. I can't even rent a home. I can't even do anything with the amount of money I make doing what I'm doing. And I'm trying to live. I live with my girlfriend, and yes, I have a house to stay at, but that's all I have left is $744 for the whole month. So when I come to the $250 is the amount that I thought was appropriate, that's kind of what I can afford to, put towards it. I have a plan for spousal and car maintenance to be paid at the end of each month in the amount of $250 until the amount is gone, minus the $1,000 that I had to pay. So if that $6,400 total brought down to $5,400, I could pay at the end of each month $250 until that's gone.
All right, thank you. Ms. Chapman, any response? You're muted right now if you want to respond.
Okay, sorry. The 50% garnishment is due to no fault but his own because of him losing his job due to stealing from the workplace. So that garnishment would not be that big if he was not that behind in another form of payments. So to me, none of this is excusable. And as far as providing for his children when he has them, he puts my son in women's clothes that his mother provides for them. And I'm just tired of the excuses and the BS and him saying, I will give her $250 a month. We have heard this countless times. And the stories and the time that I've had to do that, he says that the time that I've had to spend to do this stuff. And no, I couldn't even hold a job because of all of this stuff. There needs to be a punishment. I'm at the wit's end. I mean, this consumes my entire life. And enough is enough. And every time it gets down to the nitty gritty, he comes back with some things to submit that are not even accurate. And then after this, we won't get another payment. And then here we will go again.
So what would you like to see happen?
The previous punishment of the 5 days to be ordered, at least, and then a strict payment plan to be put in place.
Right.
And if he did not have almost $1,000 truck payment, he could afford more.
Your Honor,
I mean, my bills
I'm ready to move forward.
My bills in supporting my children far outweigh his 3 bills that he has. I'm ready to move forward too with my whole life and be done with this. It's so stupid. It's a waste of everyone's time.
All right, Ms. Chapman, I'm ready to make a decision here. On March 15th, I entered a bench order requiring Mr. Chapman to pay $1,000. That was the first thing. The second thing was to provide receipts of all spousal support payments he made. And 3 was to provide 3 months of wage stubs showing the amount that was garnished from his paycheck. He did pay the $1,000. He provided what he indicates as spousal support payments. Those are from 2021. Ms. Chapman disputes whether they are, because apparently some of those are prior to the date of separation, but that will be worked out in whatever credit, if any, those might provide. And Mr. Chapman did provide wage stubs going back more than 3 months, along with the administrative order from child support showing the garnishment. The current pay stubs show that Mr. Chapman makes close to $4,000 a month, but with the garnishments and taxes and so forth in February, I believe, he only took home around $1,627. And he is on track to do that or less in the month of March. I'm going to find that he did comply with my order of March 15th. And so I'm not going to order any jail time. Looking at the income that Mr. Chapman has provided, I guess I'm going to tell you 2 things, Mr. Chapman. There's an order in place for spousal support of $250 and also for, I believe, a car payment of $250. Plus there's back support that's owing. The last time I calculated that, it was around $13,000. I know you may dispute that amount, and that's something you could bring up to the court at a later time, but that's kind of what the financial situation looks like. The spousal support and the payment for the vehicle are still going to accrue at $500 a month. If you make $250 a month payment every month from here on out, and I would like those payments by the 10th of the month, then I will not hold you in contempt. But I want you to understand that doesn't fulfill your total financial obligation, that if you don't pay $500 a month, every month there's going to be another $250 added to whatever judgment is owed. But if the $250 is paid, then I'm going to find that you're not in contempt. And I'm going to leave things at that. If Ms. Chapman, if the $250 is not paid, then you're free to bring that to court again. Mr. Chapman, the jail time is still on the table. And if there's another contempt hearing, I'm probably going to order that. You have offered to pay $250 a month, looking at your income and the issue with the garnishment. I'm going to accept that is about the limit you can do right now. If Ms. Chapman is aware that you're earning a lot more money than what you're earning right now, then we're going to adjust things and you'll have to pay more. But right now I'm going to order the $250 a month. I hope that will be paid, going off into the future. You're still going to have the judgments against you that will have to be satisfied at some time.
Your Honor, I have a question.
Okay.
In our final paperwork, the spousal maintenance or the spousal support should have ended or should be ending, and it should have ended already. So that payment should be stopped. So I would be
never started.
I would be making just back payments on that, what I owe up to. It wouldn't accrue anymore.
I also asked for it to
Okay,
continue.
before we argue that. I don't have that paperwork in front of me. Given the back support, you're still required to pay $250 a month.
Yes.
At some point, I assume one or the other of you are going to bring the issue to court to calculate whatever credit is owing. And I suspect there'll be a disagreement, but I'm going to need more information before I can address that. Right now, regardless of how we look at it, you're going to owe $250 a month, whether it's current spousal support or past spousal support. Okay.
Okay, Your Honor. Another question: how will I be served the papers in the future? I mean, with the communication and how things are going, can we plan on doing like a mailing thing back and forth instead of any confrontation?
You don't
With-
send your mom.
Ms. Chapman, do you have any objection to Mr. Chapman mailing you legal documents in the future?
You are just required to serve them properly and not use an abusive person to do so, who files fake reports.
All right. Sounds like
That's
she's not.
I agreed to meet up with Maggie and then met there and saw his mother in the car and then turned around. That was it. And so I actually went to the courthouse to pick up the papers myself because I know how to do the things, and they weren't scanned yet, so I couldn't pick them up.
All right. Mr. Chapman, it sounds like service needs to be done. If it needs to be in person, you can do it in person. You'll need to do that somehow.
Having the
Use
kids'
a
grandmother
third party to do that.
do it is I mean, come on. And stalking like that, yeah. He could have done it. I've served him personally the whole time.
But Ms. Chapman, you're actually fading away. I'm not able to hear what you're saying.
Like I've served him like the whole time, so he could have served me like he actually stated in the first message about giving me the papers. He said he had papers for me if I wanted to meet him, and then it turned into Maggie, and then all of a sudden I was being blindsided by the person who he knew better than. It was an intimidation thing. And if I'm being clear, so he is supposed to still be required to do the $500 a month and then also the $250. I'll just go pick up the papers. It's okay. You don't have to reiterate.
All right. I've made a decision, and I'll put that in a bench order. And again, if the $250 is not paid by the 10th of the month, that'll begin April 10th. Then I guess Ms. Chapman can bring another contempt.
Okay, and I think the order was signed about continuing the spousal support and stuff for another year since it actually never started because it never got paid. So I'll pick up those papers today to be clear on that too.
Okay, I understand that. Well, I did enter judgments for the spousal support up until recently. So
yeah, it's been a minute since I think that one was done, so I don't remember anymore.
I'm not addressing that right now.
Yeah,
if you want to address that, bring
that's
that.
fine. I can go pick all that up. You don't have to. Yes.
Okay, thank you.
Okay, thank you.
All right, Brittany Chapman and Bryce Chapman.
I'm here, Your Honor.
I'm here, Your Honor.
All right. Good morning. Mr. Chapman, you brought a motion for contempt relating to the exemption, so I'll let you go first.
Yeah, so I went to file my taxes, and I had on the final divorce and all that paperwork, it included that I get to claim Brody and she gets to claim Harley and Tatum for the years or whatever and ongoing. So I went and filed my taxes and with only claiming just Brody, and they came back as rejected. And it said on there that this dependent has already been claimed for this year. So you have to refile, do all your work again or whatever to refile. So I brought it up to thinking it should be going through the contempt order because it's going against the plan. And I mean, now that I am had to refile with not claiming Brody, I am owing money, which I was going to get back $2,222 with claiming him, and now I owe $778. So I think there needs to be some kind of something figured out.
What was the amount of the exemption with him?
The amount of the exempt, well, it's $2,000 per kid. So
No,
when
it's
I
not.
didn't,
Go ahead.
so when I put it, or so when I had Brody and claimed him on my taxes, the amount that I had that I was going to get back was $2,222.
How is there a $2,900 swing in your taxes when the exemption is only $2,000? Do you understand? Can you explain?
So that's all so that's the information I put in on my taxes, and I did it with him, and I was getting back $2,022, and then I did it without him, and I owe $778.
Was that like through TurboTax, or did you go to some agency?
That was through TurboTax.
All right. Ms. Chapman, any response?
Yes, Your Honor. I prepared something, but also to touch on what he had just stated. The tax credit for children is not $2,000 this year. Mr. Chapman also does owe the IRS taxes, I think $3,000 from last year's taxes when he filed, that has nothing to do with me. So all of that is highly unbelievable. But I myself was very shocked, as well as a bit humored, when I received the contempt papers from Mr. Chapman. Again, very untimely, as the papers, as you have seen, were filed on March 31st, and I did not receive them until April 14th after the court was closed. So 2 weeks after filing the papers, and also leaving me with only 2 days to speak for myself. So therefore, I have not gotten to file what I could be yet again. Your Honor, Mr. Chapman's retaliation and manipulation efforts again show the court the frustrations I have had throughout the course of almost 2 years, and especially with all of the true contempts I have had to file recently on him, which he continuously got out of with lying to the court and manipulating the system. Not only have I sent him pictures of receipts with totals and calculating his half of baseball and softball costs on March 10th, and he has ignored every one of my efforts to receive his court-ordered half of those costs. So I, during a phone conversation, informed him that I may end up having to file him in contempt for that. But I really did not want to have to bring this all back to court. If going back and forth to court was something I wanted, I would have brought him not paying his half of school clothes, school supplies, football, basketball, wrestling, him not having the kids on his insurance, and many other things he does not hold up his court-ordered end of in front of the court. But I have not. I have only brought a very few amount of things. I have also learned that after all the last, I believe, 5 contempts, he has yet to face any true punishment. And considering he finally, after being forced to by almost being given jail time, paid me his first spousal support payment, and considering he finally, after being, in an entire year of being ordered where the amount was even cut in half for him at our last hearing, I had faith in him that maybe this time he would do his part for the kids and just pay his half of the sports fees. So I waited, and a week later to file the contempt on that. And a week later, he serves me with this, almost trying to beat me to it or retaliate on what I was just filing in contempt for a month prior. This also being the very first paper he's filed in almost 2 years. I have, the court order where it got ordered that he claimed Brody on taxes was signed on July 19th, 2022. Therefore, that was a little more than halfway through the year. And my tax professional stated that since it was halfway through the year that it was ordered, that it would be next year that it would play into effect. And I financially provided for him and our other 2 kids that I was to claim him because I provide every single thing for them. I also have something to bring to the court that is not relating to what we are here for today. That is an even more serious thing. I just have not got the time to do so, as this was just brought to my attention very recently. That is another contempt. I could have asked for an extension for today, but I don't think it's needed to waste more time. And I think this all speaks for itself. Mr. Chapman owes me upward of $24,000. So him asking to take money from the house his kids live in from the person that raises them with no help physically, emotionally, financially, or any of the other things without the force of the state from him truly did break my heart and make me physically sick. Thank you.
All right, Mr. Chapman, any response?
Yeah, I mean, there was a lot said that, I mean, we're here about, you know, figuring out the whole, who's claiming what and when and all that. And on the paperwork, it says that, you know, I am to claim Brody, for the years, and she's to claim our 2 daughters for the years. So that's where I'm at right now. And like I say, any money I get from that, like I stated on there, I would be paying, and it would be taken off my amount. So that's where I'm, you know, coming from. I just, you know, now I owe more money. I mean, you saw my paychecks, you saw what I make and what I bring home. I mean, I'm doing what I can to live, and, you know, she's got her boyfriend there at the house that, you know, works full time, and, you know, she's not the only one that is around the house. So
Why my
I'm
car's
just here on the order.
any day getting repoed.
I'm just here on the order
I'm gonna
of,
let Mr. Chapman finish.
I'm here on the order of, you know, me claiming Brody, and I go to claim Brody, and I get rejected, and that's on the final paperwork that says that I claim Brody. So.
All right. So I'm looking at the June 15, 2022 decree of dissolution, and it says Bryce Chapman claims Brody Hancock's every year. There's also a box below that says, although the personal tax exemptions are currently suspended under federal law through tax year 2025, other tax benefits may flow from claiming a child as a dependent. As I've indicated, I'm not sure I understand how a $2,000 exemption nets somebody $2,900 in benefits, but I'm willing to look at that. And I'm sorry to make you come back, but what I'd like to do is come back on May 3rd. And Mr. Chapman, you're going to have to run on TurboTax those 2 scenarios that results in that difference so that I can take a look at it.
Okay.
And so I want to consider that. I'm not finding contempt. I will decide if I'm going to do that at the next hearing. But right now, I have no basis to make any kind of monetary allocation. And so I'd like to look at that before I make a decision on it. Okay. So,
Okay.
and those should be filed what we call under seal with the clerk, which means they'll be private. And so your personal financial information will not be open to the public. Okay. And then provide a copy to Ms. Chapman. That should be done by early next week at the latest. And then we'll see you both back here on May 3rd. Okay.
Your Honor, I have one question.
Sure.
When he does do taxes, I mean, he owes like taxes to the IRS, and considering he owes so much back child support and back spousal support and stuff, it goes to me anyways. So I don't understand. And also I only got $2,600 in taxes. So he's under this impression I got like $10,000 and I did not. So this is all crazy to me. Like I'm literally about to lose my car, and he's asking to take money from his kids who where they like I don't know. I guess we'll
I
see
understand
back.
that.
This is just
Understand.
cracking me up and grossing me out, and it makes me want to puke.
Ms. Chapman, I think I understand
awfulness.
your position in this case. As I said, I haven't decided if I'm going to find contempt yet. If
That's
you'd
okay.
like to
I'm just upset
file-
over just the fact of it.
If you'd like to file a further response for me to consider
I honestly just don't even care anymore.
by May 3rd, you can do that.
It's okay. I don't care anymore. I'm done.
All right, we'll see you back here then. Thank you.
Thank you.
All right, next, Amy Kingsley. And we'll
That's to address finances only.
yes.
Thank you, Your Honor.
Okay. All right. Thank you both.
Thank you.
Excuse me, Your Honor. It's Brittany Chapman. I have to go pick up a kid from school who is super sick. Is it okay if we go next? I hate asking that.
All right, we'll take the Chapman and Chapman matter then.
Okay, awesome. Thank you very much.
Is Mr. Chapman here?
Yes, I am.
All right, let me get to my notes on that. All right, Mr. Chapman filed some tax forms with the court. I'm not sure that I completely understood them, but his issue here is he's claiming, and the current, I think, child support order gives him a credit for one of the children, which was apparently $2,000 this year. And so he's wanting that much credit against the contempt and judgments that I previously entered. Ms. Chapman, do you want to respond to that?
I mean, no, I didn't get $2,000 per kid, so I stated that at our last hearing. So I mean, no, I'm okay.
Well, did you take a $2,000 credit for each of the children?
Did I get one?
When you did your taxes, you claimed
Yeah.
the 3 children, right?
Yeah.
And do you know how much of a credit that was? How did that play out on your taxes?
I'm not sure exactly how much it was per kid because I only ended up getting 2,600, I think, back. So there's obvious that I didn't get that much per kid because I barely even got that much total.
All right,
So I am not-
Mr. Chapman, any response?
Yeah, on page 3 that I copied, it says child and other dependent tax credits. It says in 2022 on my picture $2,000. Then the earned income credit for 2022 $138. So if you go to the very last page, it shows that I would get a return of $2,222 for my refund. And in the very first page shows that I owe $778 now since I wasn't able to claim the 1K Brody. So that's where I'm coming at right now. So now that I was put in this situation, there's $2,222, and the $778 that I have to pay now. I think so close to $3,000 to be taken off my amount because I'm having to pay $778 now for my taxes.
Okay. Yeah.
Any response, Ms. Chapman?
Yeah. Okay. So, he was not put in any situation that he didn't put himself into or bring himself into. Also, the money that he owed the IRS the year prior to this one, that has nothing to do with me or anyone else other than him filing exempt on his work forms, the W-9 or whatever that form is called. He went exempt on those multiple times so his paychecks would be bigger so that he would have more money for drugs and alcohol. So therefore, him owing the money to the IRS the year prior has nothing to do with me. So the $748, I think last time your actual question that you wanted to know and him to submit was how the difference in the $2,000, like his amounts didn't add up. With Brody and without, like his totals just did not add up. And him owing, like, so once you get to the submit your taxes part of it, your amounts change. So it just depends how much all the things, all the tax logistics of that I don't know. He very well probably wasn't even going to get the whole $2,000, especially considering he owed the IRS still, and it all would have been given to me regardless because of the $24,000 in back support he owes me.
So, Your Honor, it breaks it down all for you on 2022, the year 2022 on my papers that I sent you. You can break it all down and see both incomes of both outcomes of if I claim Brody or if I do not. And she's saying that it will go to her no matter what. Yeah, but then my balance that I owe her already, that will stay the same. So that's what I'm asking for. So that can get dropped off that balance. I'm not asking for her to pay me cash money. I'm asking for that to be taken off my balance so I don't have to pay another $3,000 to her that she took from me already.
Oh my.
I need to make a decision here, and the current child support order does give Mr. Chapman one of the tax credits for the children. And that apparently was used by Ms. Chapman. So there is a monetary effect on that. I'm not sure that it's $2,000. And I can't make that out from the documents that have been presented to me. So what I'm going to find is that Mr. Chapman is entitled to a credit of $1,000 against the amount that's owed to Ms. Chapman. I know that's in excess of $13,000, but whatever's owed, there'll be a credit of $1,000 for this tax exemption, and that should take care of it. All right. Thank you both.
Okay. Thank you, Your Honor.
Thank you, Your Honor.
Your Honor, I have a quick question.
Who is this?
This is Bryce Chapman.
All right, what's your question?
Can we move our meet or our thing till June 7th? So I have time to respond. I have papers that I'm getting ready to file in by the end of this week.
Your Honor, he had 21 days and you haven't called our name yet. I was going to ask for a default judgment anyways, but it's not our turn.
All right, so Mr. Chapman's asking for a week delay. Is that right?
Yeah, just until the 7th. That way I have time to turn in my papers.
He never
what I'm doing by the
responded.
end of
He
this
had
week.
time. He had 21 days, which is the amount of time they have to respond, and he chose not to.
I received the papers from her 2 weeks ago.
Which is plenty of time.
All right, we're going to go
Actually,
for
we're gonna-
the hearing. I'm not going to continue it at this point, but we're not taking it right away. All right, we're going to take Chapman and Chapman next. There's two motions, one motion for contempt and the other one for adequate cause. I'm denying Mr. Chapman's request for a continuance. Ms.
Thank you.
Chapman, do you want to go forward?
Yes, please. So, Your Honor, the safety of my kids, like any mother, is my biggest concern, as I thought it was always Bryce's as well, at least until the last year of our marriage, when he would sneak drinking every single day, as well as on numerous occasions drive us all five somewhere while intoxicated, and I would not be aware of that until afterwards. It all started then, which is one of the things that led to our divorce. After Bryce moved out, he promised he was done drinking and doing cocaine, as my final straw in our marriage was taking our kids to the 4th of July carnival, where Bryce claimed he was only going to use the bathroom and was gone for 15 minutes while the kids got their faces painted and returned with snot and cocaine residue dripping from his nose. So those promises meant a lot to me. It meant maybe we would be getting the real Bryce back. He went to only 2 AA meetings and never returned to another one. Skip forward 1 year to we were going to court, and I end up getting my car back in the middle of going through a custody battle, which here we are again, and finding it full of alcohol, to which he loses most all of his custody. It's been a year since then, and at the time of that court date, he was so upset about losing his time with them, told them he was done drinking yet again, said he is going to fight for them and put them through some very big emotions that they were way too young to understand. What?
I'm muting whoever was speaking.
Oh.
Go ahead.
Through some very big emotions they were way too young to understand, and after a full year, not only has he not quit drinking, not given them a home or beds or any sort of reliability, he doesn't show up to most visits, ignored them, and no called, no showed them for 2 whole entire months, has used only 6 Wednesdays in an entire year, has moved an hour away in that year without letting anyone know. But Your Honor, the worst and most terrifying thing is that I still have to send my children twice a month if he shows up. Somewhere that, rather than feeling happy and excited for them that they get to spend time with their dad, instead I sit with my phone on loud in case I get that call, with my brain constantly racing through every what if, and just hoping that they will, number one, be smart enough in that moment to remember all the things I've had to teach them about what to do if you're about to be in a car with someone who has been drinking, and number two, that they could remain strong enough to do so with it being their own father. And or a lot of weekends, it's a lot of convincing and tears to get them to even go. They fear their own safety as well. They're tired of living in one bedroom, not having rooms or beds, and all 5 of them sleeping in a bed with him and his girlfriend. Brody, the 11-year-old, has tried faking sick on numerous occasions so that he doesn't even have to go. But Your Honor, I have to force my kids into an unstable, unsafe, and unknown situation just because, well, it's court ordered. It's been the toughest thing on us this far. I do have a recording of Harley, our 7-year-old, stating how he drank beer and drove on the weekend of April 29th while driving 4 hours
along with his girlfriend, her son, who is 4, and our 4-year-old Tatum in the car. Our son Brody stayed home because it was his first baseball game, to which his father didn't attend. I'm sure you're wondering why it has taken me so long to file something, and while it's pretty simple as it is complicated, the last thing I want for my kids or Bryce is either of them to have less time together. All I've wanted and waited for is for things to get better. Bryce and I have had many, many talks, one of which my Ring camera on my front door recorded, which I can use because it records a public area, where he admits he has a cocaine and drinking problem, and he states, "I'm getting out of that crap. I'm done with it. I'm done drinking." It's been over and over again. I've been foolishly manipulated by his words and allowed myself to believe them, because if what he said was true this time, then that meant the kids wouldn't be any more affected. Their dad is finally coming back. Unfortunately, the more and more I hear, the more and more the kids talk to me, and the more I see, I just can't sit back as I am these kids only. This kid's only advocate. A few hearings back for contempt, you mentioned I should think about bringing the parenting plan back to court. And at that time, little did you know, 2 weeks prior, I had actually retained a lawyer to do that all for me, because I just couldn't handle this anymore. And this was going to be a big thing to tackle. But she was just taking too long. So I had canceled her, got my mom her money back, and decided to take it into my own hands. And then he decides not to respond to anything, but then 2 days before court wants to text me telling him I made him very unhappy and maybe we can find an equal ground, but yet can't care enough to actually respond, but can show up to court, which I just presumed would happen. So with this all being said, I would like a default judgment to be ordered, if at all possible, Your Honor. Thank you.
All right, thank you. Mr. Chapman, any response?
Yes, Your Honor. So my response that I would have for you on June 7th, all my papers I have included, included a drug and alcohol test. I have it scheduled for the end of this week. I was going to include that in the papers. All that being said, this is about, I feel a bunch of retaliation that she's trying to get back at me, trying to get me in trouble, trying to get me to go to jail. She's doing everything she can to find everything and anything for me to be contempt, to where I can be in trouble. That's all she's ever wanted, and that's all she is wanting, is me to go to jail. Just like every other contempt order, she's asking when my penalty is going to happen. My kids love being with me. They tell me every time, and they cry and they're upset when they have to leave, when I have to drop them off. There's no issue at all whatsoever. They tell me that they want to be with me. They want more time with me all the time. So with that being said, I mean, turning in my drug and alcohol test, doing all this, I mean, that's what I was going to have for you on June 7th. But like I said, I just needed another week to do it.
I have a very short response to that, Your Honor.
Go ahead.
My kids get really upset when they come home, because they have so much fun when they're there, because he doesn't get to see them a lot. And they've expressed to me that they're just worried if he's going to show up the next time. So they do get upset when they come home, because they just don't know if he's not going to show up again. And these things, Bryce is very clueless too, just because he doesn't know, because he's the take him and play on the weekends when it's convenient person. So he has no clue about their emotions and their feelings anymore, and what really goes on. So of course, yes, they do. They love when they get to go hang out and play, but I do have it documented, the times when they don't want to go, and when Brody has actually not gone. But that's what that is. They're afraid of him not showing up again. And as far as him submitting any drug and alcohol tests, I mean, it's cocaine. He can pee clean within 2 days, and he's very good at that. So that's fine. And also, I'm not asking him for him to go to jail. So that's far from retaliation, and I can prove when I retained the lawyer, and it was far before any of those things. And I'm pretty sure I have multiple parenting plans that I have filled out multiple times regarding all of this long, long ago. And that's all.
Okay. So one of the motions that was brought was a motion for adequate cause. There was a parenting plan entered on June 15th, 2022, regarding the party's 3 children. And in order to change that, this court initially has to determine if there's adequate cause to make a change. And if there is, then it would be put on the trial setting docket for a hearing in front of a judge to determine if a change should actually be made. I'm not determining that change. I'm just determining whether there's enough evidence to go forward with that. The statute addressing adequate cause is RCW 2609-260, and I want to read part of it. So it says the court shall not modify a prior custody decree or a parenting plan unless it finds upon the basis of facts that have arisen since the prior decree or plan, or that were unknown to the court at the time of the prior decree or plan, that a substantial change has occurred in the circumstances of the child or the non-moving party, and that the modification is in the best interest of the child and is necessary to serve the best interests of the child. What I've been provided for today is that the parenting plan has not been followed in a couple ways. The Wednesday visits have not been utilized, and there apparently was a long gap of time when Mr. Chapman did not see the kids.
As well as still drinking while he has them.
Okay, it's my turn now. Okay.
Sorry.
There has been some indication of drinking. That's come from the children. I think that's an issue that probably needs to be addressed, but I think simply with the failure to follow the plan, and I'm going to accept Ms. Chapman's testimony about the impact on the children, is that it causes them to be concerned about when their dad's going to come back next. I think that does provide adequate cause, not having to do with anything with the moving party, but having to do with the non-moving party. So that evidence fits within the statute, and I am going to find adequate cause and sign the order for adequate cause. At this point, I'm going to deny the contempt order without prejudice. I think the effect of all of this is that you're going to need to go back to court and discuss all of these issues, and the court's going to consider it in fashioning either a new parenting plan or do something with the current one. I'm going to place this on what we call the universal trial setting calendar. And today's the 31st. I'm going to put it on the universal trial setting calendar for a 1-day parenting plan trial for June 14th at 1 p.m. That's when you're going to get the date that this will be heard. So the June 14th hearing will be a fairly short one, just to get a date when it will be heard. I am going to enter one bench order in this case. The current parenting plan is not going to be changed at this time. I am going to order that Mr. Chapman not drive more than 30 miles. One of the issues apparently was a long drive where he stopped to get beer on the drive. So I want to try to address that by putting a 30-mile limit on where he's able to drive with the children, and hopefully alleviate some concerns. So that's where I'm going to go today. Okay. So you'll need to be back in court then on June 14th at 1 p.m.
Okay. And
Okay.
your
Your Honor, I have a question.
I'll let Mr. Chapman go first. Go ahead.
Okay, so with no more than 30 miles, and I am an hour away, my parents is half an hour away. That's where she was gonna drop off and pick up or do whatever too. Can we meet halfway in the middle? And because that's less than 30 miles for me, do like a Woodland Walmart.
Which Walmart?
Woodland Walmart. It's right off the freeway, and it's halfway in between both of us.
Ms. Chapman?
Yep, that's what I asked for in the plan.
All right, so you can meet at the Woodland Walmart. All right.
All right.
Okay, and Your Honor,
Yes, briefly.
in the last parenting plan that we had already had prior, he is ordered not to drink, period, when he has them, or 24 hours before. So that contempt, he's not in contempt for drinking with them.
I'm not finding that at this time. That order, however, Mr. Chapman, you need to know remains in effect.
Yes.
Okay. All right.
Thank you.
All right. Thank you both.
Bye-bye.
Thank you.
The next hearing in the case was on June 14th for the trial setting docket. I don't have a copy of that stream, but we can see from the entry in Odyssey that instead of moving ahead with the trial, the parties decided to go to mediation.
Brittany Chapman and Bryce Chapman, 21-3-34608 is the next cause. So Brittany Chapman, are you on the line? Okay, no response from Ms. Chapman.
I'm
Bryce?
here. I'm sorry. I couldn't get my phone to unmute.
Okay, Ms. Chapman's present. If you'll turn on your video, please. Okay, thank you, Ms. Chapman. Then Bryce Chapman, are you on the line? Bryce Chapman?
He is not. I did not I couldn't find him to see him and do that, but I also just got back from the courthouse to pick up even more stuff that is just came about.
Okay.
So
as far as Mr. Chapman's present, Ms. Chapman, did you serve him with copies of the documents and then submit a declaration of service indicating that he had been served?
I have not been able to serve him because he won't communicate and I don't know where he is.
Okay.
I see him on Friday and I'm hoping to have this huge stack of other stuff filed before then.
All right.
There's a lot of safety issues that my children brought to me.
Yeah, so any of the concerns that are in your motion for contempt, we won't discuss those specifically here today, simply because there's been no proof of service that he has been served. And so what will need to happen is that you'll need to get if you think you can serve him by a certain date, and then set up for a hearing. Sometimes people will serve the person and then give them a notice of a date later. So generally what needs to happen needs to be generally it needs to be 3 weeks in advance.
Yeah.
So if you can go ahead and serve, and then you'll have to re-note it up for a hearing. So once you get that service, it can be
Okay. I thought I was going to see him and then he avoided me. So that's what this problem is. But do you think I can make the court date the same for the papers I'm filing right now as well as those ones?
Okay, Ms. Chapman, it looks like I froze there for a bit and you froze also. So the next step would be you'd need to serve Mr. Chapman with your documents related to the motion for contempt. And then give him a docket notice and then have it set for a particular date when you serve him, so he knows what date to come to court. And so
Okay,
that's the next step. So we won't
so
set.
then the papers I'm filing this week that are, it's so much stuff. Do you think they'll be able to do the same court date for both of those?
They potentially could, it depends
Okay.
on what the date that you choose to have them come to court on the contempt. And if
Okay.
if you align that with the other matter, potentially they could be on the same dates or they could be on different dates.
Okay. Okay, they're set to go with him on Friday, but there's a huge safety thing, so I'm trying to get all of this done and I don't know. Okay.
Okay. All right.
All
So
right, thank
go ahead and
you.
take care of that service issue, and then once you've got it served and noted, we can hear it on the docket.
Okay, thank you.
Okay, thanks. Next, I have Brittany Chapman and Bryce Chapman, 213-34608 is the cause number. Looks like we have Mr. Chapman present in the courtroom. He's taking a seat. Welcome, Mr. Chapman. And then I'll ask you if Brittany Chapman, if you're on the line.
Yes, I am.
Okay, Ms. Chapman is on the line. Welcome to you.
Hello.
Okay, so this is a motion brought by Ms. Chapman for contempt and also a motion for adequate cause to modify the parenting plan. So you probably both heard me talk earlier about notice and opportunity to be heard in an earlier case, if you're listening to that. So I'm looking at this declaration of service that was filed by Ms. Chapman. So the amended summons for the motion for adequate cause was served on the 15th of September upon Mr. Chapman.
Correct.
So generally, there needs to be 20 days from a summons being served until that person has to respond or appear. And we're premature on those 20 days.
He did respond. I'm just not sure if he was able to give the proof of service to you guys yet or not.
Sure. No, I recognize he has responded. I recognize that. But procedurally, I just wanted to point out that shortcoming. With any rule, any party can waive the requirement. You can say, I want to enforce the rule, or I'm okay, let's move forward with it. So, Mr. Chapman, what's your vantage point on service?
I also do want to put in my copy for a parenting plan. Put forward towards that too.
Your proposed parenting plan?
Yeah.
Okay. Then let me ask Ms. Chapman on the motion for adequate. Okay, so let me just pull this up. I've got my notes here. On the service, one of the requirements is with service that a litigant can't be the one that's doing the service. It has to be a third party. And they can be related to the case, but it can't be one of the litigants. So when I looked at the declaration of service filed on the 26th of September, this was filed by Ms. Chapman. It indicates that it says, my name is Brittany Chapman. I am not a party to the case. I'm 18 years or older. So I'm just making sure, I'm assuming, Ms. Chapman, that that's you, not another Brittany Chapman.
No, that's me. And the people at the court clerk's office or whatever had told me I had to put my name in there anyways, even though I am a party to the case. And we did the personal service forms. I don't know if that makes a difference. It's what I've always done.
Yeah, so looking at the second page, where it says, I declare under penalty of perjury that the statement on these forms are true, and it says signed in Woodland, September 15th, and it's signed Brittany Chapman. So what that tells me, and it may be a Scrivener's error, wrote in the wrong name, it says that on September 15th, Ms. Brittany Chapman served the parenting plan change, proposed parenting plan, information regarding parenting plan, declaration of Jocelyn, declaration of Brittany, and a notice hearing for today, that she personally gave those to Mr. Chapman. So under the way that document is presented, that violates that rule that a litigant cannot serve the other party. It has to be a third party.
Okay. I had no idea about that because they said it was fine.
Yeah.
Every time.
Yeah, and I'm not faulting anyone. I'm just kind of laying out what the rules are,
Yep.
and that not all of us spend our days in court, so we don't know all of these things off the top of our heads.
Now
Understandable.
I know.
So, so then the motion that is the declaration talks about those particular motion, the parenting plan motion, the motion to modify the parenting plan, and the declaration supporting that. So that particular motion is not really primed and ready to go because there's not been proper service, meaning, and some people will fault the court for this. It's like, well, hey, we gave Mr. Chapman all the documents and you're just saying just because I did it, we can't move forward today. Yeah, that's what I'm saying. It's fidelity to the rule. So the rule says Ms. Chapman can't be the one that's serving the documents. It has to be somebody else. So that particular motion, we're not going forward with it today. That doesn't mean that it's dead in the water, but it's just for now, today, until there's proper service with a proper declaration of service, we would not be hearing that particular motion today.
Okay, can I ask a quick question?
Please.
A couple years ago, I was the only one who served everything, and it was never a problem, which I understand there's rules, but I just had no clue. And then he also personally served me his declaration or his response. So, yeah.
Yeah, and I recognize that, and I apologize if that led you down the wrong path or led both parties down the wrong path. But that's the rule, and I'm going to enforce the rule.
Okay, so now what should we do? Just
Yeah, it's a valid question. So there's the motion to modify the parenting plan. We can't hear that today. There needs to be proper service. So once there's proper service, then you could note it up for a hearing just as you did today. So there need to be service provided to Mr. Chapman by a third party, and then the declaration of service would need to be filed, and then a docket could be set where that motion could be heard, giving him sufficient time to respond and you to read and digest his information.
okay, and one more question.
Right.
Since it's in concerns of their safety and they go with him again before this would all happen, there's still nothing. We still have to wait.
So there's, on the kind of the substance of the motion and modifying the parenting plan, it's not properly before the court. The court can make some interim or emergency rulings related to safety. One of those concerns may be alcohol and driving, if that's a concern. Hopefully that's not an issue, but I can order that today, that Mr. Chapman not do that. And I'm sure he would abide by that between now and then.
Ordered that.
Yeah, so that issue, we on a kind of an emergency basis, I can address that if that's the safety concern that you mentioned.
It is. It's a big one, and they are
Okay.
to the point where they try to refuse going because they're afraid. And
Okay.
he's already been court ordered before not to drink while he has them at all, and he is doing so again while driving. So they're scared.
Okay. All right. So then the other issue is the motion for contempt, which I'm taking a look there as far as the
I have not
declaration
had
of.
time to do proof of service to the court yet.
Oh, could you repeat that?
I have not had yet time to prove or do my proof of service to the court yet. I have it. I just haven't got to turn that in.
Okay. All right. So let me hear from Mr. Chapman. We've talked a lot about a variety of things. As far as the motion to modify the parenting plan, that's not going forward today. There needs to be the proper service. Do you have any questions on that?
I do not.
On the motion for contempt, that's where we talked that there looks like there's Ms. Chapman had indicated that there wasn't the declaration of service related to that. And I know that you filed some response to that.
Right.
So I don't know if the parties want to move forward with that today, the contempt issue, or want to wait until that service is proper. So I'll just hear from each of you, Mr. Chapman.
I'd like to do it all at once. That way we get everything all done and hopefully not to, keep on coming back and forth.
So let me ask you a clarifying question on that. So it sounds like Ms. Chapman is probably going to move forward with the motion to modify, and she's going to do the reservice. So we'll be back at a future time for that issue.
Right.
The contempt issue, that could be heard today if the parties waive the service requirements, or it could be heard on the same date in which we come back for the parenting plan motion. Do you have a preference? Because we could do the contempt today.
Yeah, we can take care of the contempt today. That's fine.
Okay. Ms. Chapman, do you want to move forward on the contempt today?
Yes, I would like to, because it talks about the drinking and driving as well in there. So I would love to tackle something.
Okay. So then let's move forward with the motion for contempt. So Ms. Chapman, this is your motion for contempt. And what I see here, that there's 4 grounds. One is related to expenses for the children and school clothes. There's also an allegation for spousal support. There's an allegation regarding drinking and driving, and there's an allegation regarding missed visits on Wednesdays. And then there's a 5th, I guess, if you will, regarding the half of the pension or the 401k.
Yeah.
So I'll hear from you. Go ahead, please.
As far as the drinking and driving contempt goes, start at that one because it is the most important one to me on there. He was ordered in, I think, 2022 that he's not allowed to consume alcohol at the time of visits or 24 hours prior. And he's also not allowed to drive over 30 miles with the kids, to which he's doing all of those things.
Can I ask you a question on that? The 30-mile restriction, is that in a written order? I looked for that and I couldn't find it. Maybe you can guide me
I
to
think
that.
he did a bench, or is that what it would be? A bench order to that? Because
Okay,
it
so
wasn't in the parenting plan. He had done it separately, I believe. Nelson.
okay, so I see a bench order from February 2022 from Commissioner Nelson. That does not address a 30-mile radius. There's a parenting plan from June of 2022. I looked in that and I didn't see a 30-mile limitation.
I have the paper somewhere. I just don't know where.
I see the no drinking 24 hours before time for visitation and during. And I just look over it again to see if there's a 30-mile limitation, because I may have missed it when I looked at it initially.
It's somewhere. If I knew what it was called that he did, I could help you. And if I had it out, I could help.
And you think it was in 2022?
I think so. Maybe 2021.
I'm just doing a good quick search into 2021.
May rings a bell for me, I think. It's also why we had to change our drop off and pickup location, if that helps at all.
Yeah, I'm looking for something specific in writing that has a 30-mile limitation on it. And I'll tell you what I've done. I've looked through, I typed a keyword search under order. So if there has order in the title, I'll pull it up and I can see something. So I've looked since the beginning of the case in July of 2021. I'm now in October of 2022. I've yet to find an order, and I'm still looking, and I'm just going to continue looking for something that has a limitation as to mileage driving that restricts Mr. Chapman. So there's lots of contempt orders. I'm just looking through those. Okay, I've looked through every order. Not to say my search is perfect, but I find no 30-mile limitation. So I just want to clarify that. If you have other information, Ms. Chapman, that could guide me to that 30-mile limitation, I'm happy to hear from you. Otherwise,
okay, I'm going to find the paper.
Okay, so go ahead and continue related to your concern related to drinking and driving.
My kids have both came to me crying within the last 2 weeks about how they're terrified to go because he's still drinking and driving. He's hiding alcohol in the cab of his truck in a cooler. My son went and looked because he always wondered what he was doing when they stopped, and he would drink something out of there. And given past situations, he was concerned. So he looked and found it like 20 to 30 beer bottles and cans. He says he's 12, so his counting is probably not right. And as well as finding them all over their house, hidden in boots and behind their scooters and all of those places. And that is my largest concern.
Is the indication from the children that they actually saw him drink alcohol in the vehicle or in the home?
Behind the vehicle on trips. He would get out, go to the cab and drink. And then they have seen him, yes, in the house drinking as well. And then hiding, what he is drinking, to which they are accustomed to because of when we were married still. So
Is
they
the
are
12-year-old, does the 12-year-old, is he or she the oldest?
He's the oldest, yes.
Does he have a cell phone?
Yes.
Does it have a camera on it?
Yes.
Okay.
I told him, I said, well, I need pictures, buddy. And he's like, well, I don't want to get him in trouble. It's like, I just don't want to go. Like, okay.
Okay.
And this last time they came back and Brody, our oldest, had told us that I looked everywhere that there was the beer hiding and it's all gone. I'm like, well, yeah, probably. But yes, he does have his phone and pictures available to him.
Okay. All right. Okay. Other grounds for your contempt. Do you want to address the school clothes, kids' expenses, spousal support, and the pension?
The school clothes and stuff he's required to pay half of, like reimburse me for half. He never has done so. School, like sports gear and stuff, the last thing he has paid for was half of basketball last year. And we've had numerous other sports like football that just was going to happen, and then soccer and multiple other things. And then the contempt for the spousal support. There was no end date set on that at our last contempt hearing. Judge Nelson had said the amount due is $500 every month, but if you pay $250, you can't be filed in contempt. If you're filed in contempt again on this exact matter, you'll have to go to jail because of the amount of contempts there is on it. And he states that he's paid all of the past due, which according to my calculations is not right. But again, there was no end date.
Okay.
Due to non-payment.
All right. And then the pension.
Pension and 401k, I have asked him at the time it got ordered for help obtaining that, and there's nothing. He will not provide me with anything. No.
Has there been a what they call a quadro? It's a qualified domestic relations order, anything of that nature?
Is that what that's something you file with the place that holds that money, correct?
Right.
No, but I don't even know who holds. I don't know any of the information.
Okay. Okay. And then, so let me ask you about the kids' expenses, school clothes and the like. Did you send, I was looking for something in your pleadings that said, okay, I sent receipts on this day and they total X number of dollars. Please pay me half of that amount. Did you provide that?
I have provided that to him. Yes.
Did you
just
provide
not
that in the
no.
pleadings?
No.
Okay. So
I was in a rush to get this all.
So how do I know what the dollar amount is and what the basis of the request for half of the payment is?
Understandable. I again was in a hurry to try to keep them in a safe situation. So that all of that kind of just wasn't my number one priority at the time, but I can submit that proof as well for the next hearing if I need to do that.
Okay. All right. Thank you. Anything else, Ms. Chapman, as far as your motion for contempt?
I just want my kids safe and him to understand I'm coming from a place of loving our children and their safety. And I never want him to have less time with them. I just want them to be safe so that neither one of us have less time with them.
Thank you, Ms. Chapman. All right, Mr. Chapman, do you want to address those issues on the contempt?
Yes, I do. Your Honor, I do drink on occasion. I would never put my kids in harm. I love my kids dearly. I mean, I will say that I do drink occasionally, but nothing to be in a life-threatening way of, my kids or anything like that. Occasionally, as in, if I go out to dinner, I might have a drink. I would not drink and drive with my kids at all.
In the parenting plan, was there any requirement for you to undergo any type of evaluation for substance use disorder?
I see she put that in there that she thinks that I need it. There's no reason that I think I need it at all. Substance abuse, I will provide a UA if she thinks that I need it. But I don't think I need to do it every single time. I can show her once and she can see that I am clean on substance, all that, that's fine with me.
Okay.
But
So I was looking at the parenting plan from 2022, which kind of forms the basis of the motion for contempt.
right,
On page 2, it says, Bryce Chapman has a long-term problem with drugs, alcohol, or other substances that gets in the way of the ability to parent. And then it said a limitation would be no drinking 24 hours before residential times or during the time with the kids, and that attend AA meetings twice a month for 6 months. And then, yeah, so there's no requirement for an evaluation.
no,
Okay. All right, go ahead. Keep going,
It's-
Mr. Chapman. So,
Oh,
yeah.
me?
Oh, pardon me,
Oh, him.
Mr.
Okay.
Chapman, sorry.
the next one, I believe, was school clothes and all that.
Mhm.
So she texts me and tells me I need this amount of money, you know, for their school clothes. I don't get a receipt. I don't get to know what she's getting. I don't even have a word in what she gets to go buy. So if she goes out and buys $2,000 worth of clothes, how do I say I can't afford $1,000 of half of that, right? You know what I mean? I don't even have the option to say, hey, you know, maybe $100 a kid or something like that. So she just shoots me with a price and expects me to pay it. I've bought
And why
clothes
can't
for the
you do that?
kids before and, you know, gave them to the kids to bring home, a couple outfits, shoes, whatever. And so that being said, the way that it's all working, you know, with her just to be able to hand me, you know, she doesn't even hand me a receipt, but just expect me to pay half of what she says is the amount due. I have no proof of it.
Does she provide you like a listing of the clothes purchased and the
So
dollar
she
amount
doesn't-
or a receipt or anything of that nature?
No purchase items at all. She'll make a list on a cart on an app or Amazon or, you know, Walmart or whatever. And this is what I'm gonna buy. I need you to send me half. It's not even purchased yet. I have no idea.
Okay.
Same
I
with.
can't
sports
purchase them
doctor.
until I have half.
Oh, Ms. Chapman, hold tight.
So,
Each party will have time allotted to them, and if you want to reply, then I'll allow Mr. Chapman to finish, and then you can respond.
So in my documents, I put in there, and I was sending money on Cash App, and it was for soccer for my daughter. She just started playing. And so that is being paid halfway, but football, she expected me to pay half. My son ended up not playing, so then what? You know, it's kind of like a back and forth thing. I need to know for sure that he's gonna be playing if I'm paying for half of it. He didn't even get, you know, she said that he went to gear pickup and got his gear and everything. Things started kind of rolling, but he was done. He didn't play anymore. He didn't even have a practice or a game. So that, I mean, I'm paying for it. I'm getting half of what they're doing. My youngest daughter is not in anything, as I know, and she doesn't give me the schedules. I have no idea. Last weekend when I had my kids, she was supposed to have a soccer game on that Saturday. We had future plans already. And then she tells me, you know, Wednesday, oh, she has a game, by the way, on Saturday. Okay, well, I have no idea. I have no schedule. I have no proof. I don't even know that she started yet. So communication wise too is a big thing. I mean, I have no idea when games are, when, you know, things are going on with my kids. I don't hear about it.
Okay. And then you submitted, it looks like you submitted some, as far as spousal support, you submitted documentation from, it looks like March of 23 to March of 24 that you'd been paying spousal support during that time frame?
Yes, I have. And I came to here to the clerk's office and got the printed off of them. I have their sticky note written down. And the balances on it too. So it came with the balances and it totaled up to what I became my last payment of. So getting that from the clerk's office,
So what's the outstanding balance?
what's that?
Is there an outstanding balance or it's just a log or registry of the payments?
So it was, we got divorced, right here. I was $6,400, and it shows on here, this is what the clerk's office printed off for me, with Nelson and everything coming on, it totaled up to $6,400 and the dates. And then I went through mine and printed off every statement that I had that I gave her for that, spousal support, and it totaled up to $6,400. So.
And so your position is that you've paid that?
I paid that in full.
And so Ms. Chapman had indicated there was no end date on the spousal support, but you're saying there is an end date because there is $6,400.
Right.
So how do I know that there's an end date?
So there's a total amount due, and that was it.
And where does that date come from? What final decree? So let me take a quick look. I'm taking a look at that decree 49.
I think it was in one of the last contempts where he stated there was no end date.
So I'm looking at June 15, 2022, the decree of dissolution. It says $250 each month, start date March 5, 2022, end date March 5, 2023, payable on the 5th of every month. And it says whether or not there's an end date, as a matter of law, spousal support will end when either spouse dies or the spouse receiving support gets married or registers a new domestic partnership unless expressly stated below. And then it says other 1 year. So the 1 year in the March 2022, the March 2023 shows that there's an end date.
And then, Your Honor, she does have a relationship, and they are supposedly, getting married and doing all this. So it's
No, we are not.
Ms. Chapman, I'd ask you to refrain from interrupting.
I know, I'm sorry.
She puts in the orders too that the stepdad, or who they call Milo dad, over there at their household, he lives there 24/7 and takes care and helps with kids.
Okay.
He's also one that drops off and picks up and does stuff too.
Okay. All right. And then what's your position related to the 401k and the pension?
So those are pretty much, that was when I was in the union. I can see what I have in there if I have anything, but I doubt I've lost quite a bit in there. So I didn't get vested in the laborers union, so I can look into it, but I really don't think there's much in there.
So as of June 15, 2022, half of the 401k and half of your pension is due to Ms. Chapman. So there'd need to be an analysis of what the value was on that particular date, and then half would be transferred to her.
From those time periods?
Yep.
What was the time period?
The decree was entered on June 15, 2022.
And until when?
It says half on that date, whatever the value was on that date, June 15, 2022, half of the pension, half of the 401ks needs to be transferred to Ms. Chapman.
Okay, so from the previous, from there.
Yeah, on that date,
All right.
whatever the value was on that date.
Right.
Certainly from that time, there's probably the stock market has gone up. So your values are going to be greater, but as of 2022 is the time frame that the 50% is calculated.
Okay, yeah, I'll look into it, but.
Okay. Okay. Anything else on the motion for contempt?
Was that the last thing to?
That pension was the last item on my list.
Okay, yeah, that's it.
Okay. Ms. Chapman, you had a few things you wanted to say.
Yes, number one, I am not getting married ever again. Number two, her soccer game this last weekend was also an abrupt thing for us as well, because she had her staph infection on her leg and everything else, making it to where she couldn't go at all. So when I found out on, I think Thursday, about her game, I let him know. I always let him know. And as far as paying for, he did end up not playing because he wants to focus on his grades, because last year he struggled. So he chose not to play. So I never ended up continuing to ask for the half of payment of stuff because I didn't have to order it. And Oh, now I'm losing my train of thought. Oh, and the spousal support, it's 250 a month, but the amount due is technically 500. So he's only paid, according to me, like 3,500. So I don't know where we're getting the 6,400 from, because he only paid 250 for a year.
Yeah, help me understand your position there, because we looked at that decree of dissolution that set the spousal support at 250 per month for a period of 1 year. And now you're telling me that it's 500, and I'm not quite sure where the 500 per month comes from.
Because it was always 500, but he never paid for a whole year. So after, I think, 11 contempts being filed, or maybe just 7, I don't know. There was a lot. Judge Nelson had changed it and just said, okay, the amount total due is 500, but 250 is paid, then you can't be in contempt. But if he doesn't pay the full 500, then
Contempt would be on the table.
then they're still stacking the 250 every month that he's not paying from the 500, just adding up.
Okay.
Does that make sense?
Yeah, I think so. What you're telling me is that, yeah, $250 is the amount owed based on the order, and that there was arrearages or non-payment, and then there was a desire by Commissioner Nelson that those would be paid, so basically double the payment. So it would be that he could purge the contempt by making that $500 a month payment.
I don't know if he could purge it by doing that. I think the purge amount was 1,000 originally, and he paid that. But basically, they just cut his payment in half to where I couldn't file in contempt if he paid the 250.
So
but if he paid the 500, great, because that's the amount due.
let me ask you, it looks like Mr. Chapman filed some documents showing $250 payments from March of 23 to, well, it looks like it started maybe, November, let me go back here, March of 2023 to March or August of, well, December 23, there's a January 24 payment, there's a March 2024 payment. Did you see those documents that he filed where he's showing a payment of $250 to you?
Yes, and I'm aware I got those, but it's still not all the way, because if you 250 times 15 months, that's only 37. So it's still not paid. He still has the 250 on top of that was not paid every month of those that is still due.
So help me understand this. The decree says 12 months at $250. So if you have 12 months times 250, that's $3,000.
Yes.
And have you
And
received?
he even said his outstanding balance was 6,400.
Repeat that for me again.
And he also states his outstanding balance was 6,400, which is correct, but that's still only $3,000 paid. And again, in one of the contempt papers, it states somewhere that the amount total due is 500. Can't file contempt if he pays the minimum of 250.
Okay.
And now am I making sense, or am I really confusing you?
No, it makes, I mean, it's a little unclear, but it makes sense what you're saying. It makes sense. Let me just, there's one other question I was going to ask.
Oh, I have one more comment before I lose it. Where he says how he would never drink and drive with the kids. There's very much proof from the last time he was caught up with that he will drink and drive with the kids. My car was full of alcohol where my kids were at that morning. So to say he never will is hard, because he does, in fact, do that, and my children aren't lying to me.
Okay. Thank you, Ms. Chapman. The clerk pointed me to a document. I'm just going to take a look at it. It's a February 1, 2023 order on contempt. Okay. All right. Thank you. Anything else, Ms. Chapman?
I don't think so. I really don't think so. I don't want to do any of this. That's what I do know.
Okay.
But I have to.
for my kids,
Okay.
and I have to be their advocate. Unfortunately, because here I am.
Okay, thank you. All right, so let me just go ahead and give you my ruling on the contempt. There's a contention that Mr. Chapman is drinking during the time that he's parenting and also while he has the children in the car, and he's drank or he's drinking while driving. And that's supported by statements from the 12-year-old who said that he saw, 20, 30 bottles in a cooler, finds bottles hid around the house. And the one instance where they say that they saw him drinking was during a trip someplace where he went around the corner and drank something. Um,
My 9-year-old as well.
so so in order to prove a contempt, there needs to be what we call a preponderance of the evidence, meaning 51% versus 49% or 50.1 versus 49.9%. That proposition has been proven by that level. Here, obviously, the allegation is very concerning. Nobody wants their children ever to be exposed to somebody who's been drinking and driving. It's absolutely unsafe. It's unwarranted. And a lot of people I know that drink and feel that they're safe drinking a beer and driving. They may be, they may not be. You don't really know until you're in the moment of panic when you have to take evasive action. And for anybody to drive or to drink and then drive, whether with children or without children, is wholly irresponsible. So I can't emphasize that enough. People die because people drink and drive, and nobody wants any harm to come to these beautiful children. Nobody wants harm to these children. And a lot of times I think people overcompensate when they drink, or they think I'm fine. And obviously if they've been drinking, their ability to think clearly is compromised. Here, there's just not enough evidence. I think there's some valid concerns that Ms. Chapman has, but I think there's just not enough evidence there. And with the prior finding of alcohol issue or substance use disorder by Mr. Chapman, if there's anything that you can do to make changes, I would encourage you to do that, because the court can order you to do X, Y, and Z, but there's nothing that will bring a child back if you make a fatal error.
Right.
So I'll make a finding of non-contempt there. As far as the school close, what I look for with the school close, I have to base my decision on what's basically written, what's provided to the court. So if dollars are spent on clothing, there needs to be receipts. There needs to be an itemized list that's sent to the other party, and they need to pay half. I haven't seen that, unfortunately, so I'll deny that motion for contempt. The spousal support, I think, is a little more clear. I know that there's been a lot of motions related to this. The divorce decree says $250 per month for 12 months. So that's $3,000. So there needs to be a payment of $3,000. Mr. Chapman has provided proof that he provided $3,000 worth of payment. So I'll deny that contempt. The 401k and the pension is a different story. I'll find contempt there. Nothing's been transferred since 2022. So I'll make a finding of contempt. Mr. Chapman needs to talk to the people who coordinate or run the 401k or the pension and get a quadro drawn up, a qualified domestic relations order, and make sure that as of the date of that dissolution decree, that 50% of the value of the 401k and the pension is transferred to Ms. Chapman. You can purge that contempt by making payment of the 50% of the 401k and 50% of the pension. Otherwise, so I think we need to set a review on that. I want to make sure that's lingered far too long. So I'm going to set a review. Quadros do take time. So I'm going to set a review for second week of January 13th, 2025 at 1 p.m. Does that date? January 13th at 1 p.m. Does that date work for both parties, Mr. Chapman?
Said January, right?
January.
Okay.
Okay. And Ms. Chapman, does that date work for you?
Yes, it does.
Right. January 13th, 2025, we'll review the payment of the half of the value of the pension and the 401k. So I'll make a finding of contempt. I think there's been prior contempt findings, so I'm required to impose a $200 civil penalty. And so I'll impose that. So that's the court's ruling. Does any party have any clarifying questions?
I do.
Go ahead, Ms. Chapman.
So since these things of the drinking and driving has already happened, and now he is well aware to not let it be known again, and keep it hidden from them,
how is my son supposed to take pictures, and also
I
how
don't, I
am I
don't,
supposed
I
to make him
don't,
feel comfortable?
yeah, I apologize if I suggested that your child be placed in the middle of all this. Um, there's, that the drinking and driving, I think if there's concerns related to that, then you could bring a motion for, I don't, because I didn't see anything in the parenting plan that allows one party to request a UA. So you could bring a motion to ask Mr. Chapman to take a urinalysis, and he'd have to take that within 4 hours, and it would be loser pays. So you would front the cost,
Yeah.
you would pay for it, and then he takes it. If it comes back that it's clean, that there's no alcohol, then he would have to you would just eat that cost. If it comes back that there's alcohol present, then he would need to repay you. That's a motion that if you bring that motion, we could entertain that motion. And that may provide, at least on your perspective, additional safety for the children.
Okay, it's so hard because they don't know to get the proof, and I knew it would be hearsay even if it's from them.
No, and
But
I
it's
don't want to
hard.
put the children, I don't want to put the children in that position.
Me neither.
Okay, any other questions?
Yeah, Your Honor. So did you say that there's a $200 penalty on top of that
For the finding of contempt, correct?
for
For the pension and the 401k.
Okay, when does that just go on top of that payment goes through, or when is that
It's payable in 30 days.
payable in 30 days?
Any other clarifying questions?
That's it.
Okay, Ms. Chapman, any other questions?
I don't think so. I just am reserving him and doing the other proof of service, correct? Okay.
If you'd like to do that, yes, there needs to be proper service.
Yeah, something has to be done.
And then if you want to, if you want to file a motion related to the UA provision, then that's something that you could make motion
Okay.
up in your order or your request. Okay, I think we completed things for today.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.